Hi guys, welcome back to Nairobi Legal. My name is Rogers, and in this video we are going to be focusing on transfer of property between a seller and a buyer. Now this is a continuation of commercial law in Kenya part 2, and so for consistency purposes please remember to watch the two previous videos on commercial law in Kenya. Now with that a brief introduction, our focus today will be on section 18 and section 19 of the Sale of Goods Act of Kenya. And to begin with, as you can see from your screens, I want us to discuss unascertained goods. Now, unascertained goods are provided under section 18 of the Sale of Goods Act. And what we mean here is that the seller does not have the goods. So, using examples for you to understand what unascertained goods mean, here what we mean is that maybe the seller is yet to manufacture the goods that are to be sold, or if it is in terms of crops, if it is maize, it has to still be grown so that again it is sold to the buyer. The other example would be that these goods are still in the warehouse, meaning that the goods could be part of a larger group. Now, to put this into context again, using an example of Jen, if Jen has 2,000 sacks of beans in the warehouse and Njoroge wants 100 sacks of beans, remember here is that property cannot pass until these goods are ascertained. So remember that as far as unascertained goods are concerned, what you're still involved in is an agreement to sell. So property will not pass until actually these goods are ascertained, meaning that we have to shift away from unascertained to ascertained goods, meaning that if the goods are non-specific, then you have to specify them. So using this example again to explain this term, for ownership to pass to Njoroge, he has to first choose the 100 sacks of beans out of the 2,000, meaning that if you have 2,000 sacks of beans in a warehouse, property will not pass to Njoroge until he goes and he selects the 100 out of the 2,000, meaning that now Njoroge specifically knows that these 100 sacks of beans belong to me. So please remember that property will not pass until goods are ascertained, and unascertained goods mean non-specific goods, and for you to be able to pass ownership, you must specify these goods. You've seen the examples I've given you as far as this term is concerned. And so, goods are ascertained and the buyer is made aware. So you're going to see a shift from unascertained goods in section 18 to ascertained goods in section 19. Now, when we come to section 19, as I've already promised you, here the goods are ascertained, meaning that ownership passes immediately. So here, the moment the contract is made, the property in the good will pass to the buyer. Remember when we talked about unascertained goods, those goods were not specified, but in this case of ascertained goods, the goods are specified. An example would be if you go into a shop again to buy a laptop, that good is specific. So immediately the contract is made, the property passes, meaning that there is nothing that you need to do to the good to make it viable for sale. So this is going to become again clearer towards the end of this video. Now, as far as ascertained goods are concerned, at first instance property in ascertained goods will pass when a contract is made, meaning here is that if you want to buy a laptop, if you want to buy a phone, nothing needs to be done to that phone. It will just be handed over to you. So it's an ascertained good, it's specific. If you go into a shop to buy a packet of milk, you handed over that packet of milk. But if you walk into a shop that sells milk in a big container and you want to buy a liter, until the point at which that liter is measured and given to you, then it becomes ascertained. But as long as the milk is still in the bigger container, it's an ascertained good. So the other thing you need to appreciate is that also as far as ascertained goods are concerned, ownership may pass according to the intention of the parties, meaning that parties can choose to stipulate the terms in a contract to agree on when property will pass to the buyer. So remember to consider these two explanations are provided on your screen. Now, moving on to the next slide, please again remember to subscribe. We're going to be coming up with another topic called agency, and so don't miss out to subscribe and get notifications the moment I upload videos. To understand Section 18 and 19 of the Sale of Goods Act of Kenya, let me use the example on your screen. Remember that when we say unascertained goods, what we mean is that these goods are not specific. And when we say ascertained goods, what we mean is that these goods are specific. And so using the example you can see on your screen, if Jane has 2,000 sacks of beans in a warehouse, and Njoroge needs 100 sacks of beans, and these 100 are not identified out of the 2,000 to make it clear to Njoroge. Now, 2 days later, the warehouse catches a fire. In this case, Jane bears the risk because out of the 2,000 sacks of beans, Njoroge does not know which 100 belong to him. So this is the essence of understanding unascertained goods. You need to clearly understand, because if goods are not specific, risk does not pass, meaning that in this case, as you can see, Jane is going to bear the risk because out of the 2,000 sacks of beans, Njoroge could not specifically tell which 100 belonged to him. So understand Section 18 and 19 clearly, so that anytime you have a question, you're able to tell. If I'm dealing with unascertained goods, risk does not pass to the buyer, meaning that risk stays with the seller until these goods are specified. So in this situation, if the 100 sacks of beans were specified to Njoroge and the warehouse caught fire, then in this case Njoroge will bear the risk for the destroyed sacks of beans, meaning the 100 he had that was specified for him. Now, on the other side, when it comes to ascertained goods, when you walk into a supermarket to buy a packet of Del Monte, remember nothing needs to be done to this packet of Del Monte, meaning that this good is specific. If you go to buy a laptop, that good is specific. If you go to buy 1 sack of beans in a supermarket, that good is specific. You simply pay for it and leave, meaning that you need to appreciate the distinction between non-specific and specific goods as far as Section 18 and 19 is concerned. Just to emphasize what we just discussed, when it comes to ascertained goods, and what I mean here is that when it comes to specific goods, ownership passes when the contract is made, goods are in a deliverable state, and the contract is unconditional. What we mean here is that nothing needs to be done to the good so that ownership can pass. If you go buy a phone, like I said before, the phone is handed over to you. Nothing needs to be done to that phone. The phone is a specific good. It's in deliverable state. And the other thing you need to appreciate is that also when it comes to these ascertained goods, property in the goods can pass also according to the intentions of the party. Remember that much as we've said that property passes immediately, parties could agree on certain terms and conditions and specify when ownership is to pass. An example here is that if you bought a laptop town and told the shop, the guy selling the laptops, please deliver for me this laptop at my house in Kilimani, meaning that there the intention of property to pass may be when at the point which the laptop is handed over to you in your house. So understand that when it comes to ascertained goods, ownership in the property passes immediately, or it can pass later on based on the intentions of the parties. Having understood what ascertained goods mean in Section 18 of the Sale of Goods Act, when it comes to unascertained goods, ownership will not pass until the goods have been ascertained. Now, just to remember that when we say unascertained goods, what we mean here is that these are non-specific goods. And when we talk about ascertained goods, what we mean here is that these are specific goods. So until these non-specific goods have been made specific, that's when property, or rather ownership in those goods, will pass to the buyer. So remember that when it comes to non-specific goods, ownership will not pass until the goods have been made specific. Taking us back to the example that we used about Jane and Njoroge, until 100 sacks of beans have been identified and Njoroge has been given notice that these 100 bags of beans belong to you, that's when ownership in those bags of beans will pass to Njoroge. So understand the distinction between ascertained and unascertained goods. And simply put, ascertained goods mean specific goods, while unascertained goods mean non-specific goods. Now, in light of the previous discussion, this is just an overview and it's a summary of the discussions we've had so far. As we come to the conclusion, I also want you to understand at what point does risk pass. Remember, as far as ascertained goods are concerned, or specific goods, ownership passes immediately and so does risk. When it comes on ascertained goods, ownership does not pass, risk does not pass until those goods are ascertained, or rather specified. Now, when it comes to risk usually passes with property, but again you need to ask yourself every time you're dealing with risk, are you dealing with ascertained goods or unascertained goods? Because with ascertained goods, risk will pass immediately, while with unascertained goods, a risk will remain with the seller until those goods are made specific. And so, to conclude this, also you need to appreciate is that a risk can also pass independently of property by looking at the agreement between the parties. So parties can also agree at a point at which risk will pass as far as certain property is concerned. Please remember that section 18 and 19 are very different. One talks about non-specific goods, meaning that ownership in those goods will not pass, risk will not pass. But when it comes to ascertained goods in section 19, ownership and risk will pass immediately. All risk may not pass immediately based on agreement that parties may agree as far as ascertained goods are concerned. Now, this brings us to the end of commercial law part 3. Please remember to subscribe, share, like. Thank you.